So we are back, Senate Judiciary, and I believe we're moving to Matt Valerio now. Matt, are you ready?
I am here. I am ready.
Great. Matt Valerio, Defender General, and we are still working on criminal threatening, and happy to hear whatever you have to tell us, Matt.
I think that, as you know, I was around when the first bill was passed and had various concerns at the time that we were extending criminal liability to activity that was already covered by law. And for the record, I will reiterate that the activity that is currently set forth in this bill is already covered by a number of criminal statutes, not the least of which is simple assault by physical menace, disorderly conduct, reckless endangerment, aggravated assault in the event that a weapon was present when the threat was made, and disturbing the peace by electronic means, among others. I didn't go through the entire list because there are some sort of boutique crimes that over the years had been put in place to address various interest groups and the like. I'm concerned.
Matt?
Yes.
Matt, sorry to interrupt you just a second. Mr. Lawton, I'm wondering if you could just click off your video. Generally, we reserve the video for the witness. Thank you. Go ahead, Matt.
That's fine. To me, at this point, this statute, there's a statute already in place. And I asked various questions when I saw this. And a lot of it has to do with proportionality. When no actual physical harm occurs, when there is threatening behavior that is by nature communication, verbal in nature or written in nature or the like, does it need to be a felony? Does it need to be a 5-year felony? What would be the enticement to have, or why would a prosecutor decide to charge any of the other activity that is threat related, like simple assault or simple assault by physical menace, disorderly conduct, and the like, if they could charge pretty much any threat as a felony? All that ends up doing is providing leverage to prosecution to overcharge a case and then put the defendant in a position to mitigate their risk and not go to trial by pleading to a lesser offense when in fact they may believe they're not guilty. One of the things that is characteristic of felonies, unlike misdemeanors, felonies usually require some sort of physical damage to occur. The threat is so massive that it requires a felony response. And the research that I did around the country regarding felony threats usually are threats of use of weapons of mass destruction, threats involving bomb threats, threats of using chemical or biological agents. So on the one hand, there either is physical damage as opposed to verbal threat, or alone, or there is a threat of mass destruction of some variety, threats to schools, like usually it's bomb threats, threats for mass shootings, that sort of thing. The other thing that is characteristic of felonies is there is usually intentional conduct, not mere spur of the moment angry threats, and not even merely knowingly. Usually there is knowing and intentional conduct is a characteristic of felonies. One of the other areas that one of the things you look at when you look at Julio Thompson talked about true threat, and that's actually a term of art. It's not that is not a that's not just a sort of a lay description of what's going on. A true threat is one that has an imminence to it. There has to be an objective possibility that is going to happen at the time, not something remote in nature. And those are the characteristics that you typically see of felony threat type legislation. I will say I am obviously empathetic and sympathetic to the concerns of the folks who have been victimized by people who have threatened to do things and have harassed them and the like. I will say that the public defense system is not immune at all to this. When our system represents individuals who have caught the public eye, and people who have not that are charged with doing terrible things. It is not uncommon, and in fact, it is quite common for our attorneys to receive threats from the public. There have been times when I've advocated on bills in the legislature where I literally received, faxed threats from middle school kids and from teachers and from victims and the like. And they've threatened bodily harm. They've threatened people, and we've had individuals. It's not unusual throughout a given year. We've had public defenders who have been actually assaulted, not just threatened, and it's not uncommon. So we're not immune to this. We get the letters, we get the phone calls, we understand that this is a concern. There is a time, however, when you put yourself in a particular occupation or you put yourself in a position of public scrutiny where these types of things come out of the woodwork. You never, I don't think you have seen from the public defense system crimes that have been charged regarding this type of activity, because I think there's an understanding that this is the unfortunate world that we live in. When you put yourself in this type of position, that is not an excuse. The question is proportionality, and that's what I'm trying to get at through this discussion is, why does it have to be a felony? And if it has to be a felony, why does it have to be a 5-year felony to get at this activity? Was the misdemeanor that was in place not enough? Was the affirmative defense causing problems for anybody? Can anybody tell me about a trial that went awry because and something from a prosecution standpoint didn't occur that should have occurred because the statute we have is ineffective? I've not heard that. To me, this is a further tightening of the screws on an issue where actual physical harm has not occurred, and is already covered by a number of other statutes and would have been covered by other statutes had physical harm occurred. and it is a ratcheting up of the consequences to again put individuals in a position where they're mitigating their risk as opposed to vindicating their rights. And that is a concern of mine, and has been for quite some time, as we create sort of mid-level, either higher level misdemeanors, low level felonies, and the like. We don't end up actually getting, in my view, individuals have the opportunity to have their cases heard. We have people who are mitigating risk and only driving up the plea process. And again, I say this with all deference to individuals who get threats, and I understand, because I'm one of them. But the issue to me is one of proportionality. And if we are going to go to a level of felony for a threat, to me, the activity should be intentional, as opposed to just knowing. And honestly, I don't care if under the statute or under the bill, if you get rid of the affirmative defense. But if you do that, get rid of the entire paragraph, get rid of G completely. And then require that a person shall not by words or conduct intentionally threaten another person or a group of persons, and continue with your statute as it is.
Matt?
Yes.
I just want to make sure I understood you. Did you say get rid of D or B?
G,
The entire section, it was G, and it was the entire portion involving the affirmative defense. Just strike the entire paragraph. Don't say, don't limit defenses. Don't create an affirmative defense, but don't limit the ability. You can't on the one hand say we require intentional conduct for a felony, and then at the bottoms say that we can't. The kind of the sneaky part of this was it shall not be an affirmative defense to say that it did not actually intend to carry out, and then at the top say that intention is an element of the offense. So, to me, it can't. This is not about individuals who just run their mouths in the heat of some discussion or heat of some hearing or trial or meeting or something like that. This is about people who intentionally are trying to threaten somebody, and we have to make, I think, a distinction between those individuals who are out there intentionally perpetuating hate, as opposed to individuals who are caught up in the legal system and are frustrated and express themselves in ways that are, not appropriate, but the only way they seem to know how. To me, that's it may be a crime, but it doesn't need to be a felony, in my view. But if it is a felony, it better be an actual intentional threat, not just knowing that they are using these words. I would also make another suggestion, and I am very concerned about one of the things Julio Thompson brought up is the place of accommodation as a prison, because there's a lot of things that go on in prisons that what are you going to do? Put them in prison? People use bad language. They threaten each other. They threaten guards. Guards threaten them. You may want to exclude from the definition of public accommodation for purposes of this statute correctional centers. It's just it was just a thought. Now, if this thing remains a misdemeanor and you eliminate the affirmative defense, that's something I can live with, because you still have the constitutional protections under the First Amendment that are there. And I will say that while clearly I took to heart the testimony of Mr. Lawton, because I knew Kaya obviously when she was in the legislature in the House Judiciary Committee. And it was a loss for us to have her no longer there. The testimony quoting some of the academics involving the First Amendment is something to take to heart, because the technology and the like is changing the way we communicate with people. That having been said, I don't think we should be quick to try to find the limits of the First Amendment. We have to embrace all of the amendments to the Constitution, because those are as much as any other, because those are the things that are the break. They're the boundary between government's ability to impose its will on people and the people themselves. That is I don't want it even to become a speed bump. It still needs to be a barrier to what government can do when it comes to speech. I mean, free speech is obviously one of the fundamental building blocks of the country, and particularly when it comes to speech that involves political speech. That is some of the most highly protected speech there is, probably the most protected speech there is. And I would not want to see us kind of freeze people out and prevent them from saying what they need to say, because what they say may be perceived as a threat. It's one of the things that I'm always very wary of. When I look at statutes, I always think about, is there anything on the books that we already have that covers the activity? In this case, I think there is. And I said it the last time when the statute was originally created. Are there constitutional issues or limits that we need to be wary of? Yes, there are. And, we are pushing the boundaries of those. The other thing is, what characteristics of the statute are inconsistent with precedent and what we have done with similar crimes in the past. And in this case, we're talking about creating a felony as opposed to a misdemeanor for speech. So this bill rings a bunch of bells for me. And, the suggestions again that I have are that if it's going to be a felony, it should be intentional conduct, and striking the affirmative defense is fine. And that you should think about exempting correctional centers from places of public accommodation for purposes of this statute.
Thank you. Matt, I have a couple of questions, and there may be others from committee members. First is a comment, and as well as a question. Threats don't always result in physical harm. The threat to do harm can result in what the threatener wants. For example, the Kaya Morris case, where the threats drove her out of office, and that's what evidently that person or group of persons wants it. Secondly, we have no idea how many election workers did what Trump wanted. We know that the Georgia Secretary of State didn't and stood up, but we don't know how many actually did something because they were threatened. Third, I'm curious about, on the prison side, I tend to agree with you if it's within the prison, but I know of cases where officers' families have been threatened in their home if they didn't do certain things by relatives of the prisoner and etc. So I want to, if we do exempt them, is there a way to make clear that it's only within the prison walls, one prisoner to another, or one guard, or something like that?
You're talking about, there are a couple of things here. Number one is, I mean, we're in Vermont, we're not in Georgia. So I'm not as concerned about, the ability of Trump's people to threaten people in Vermont. I understand that Georgia bothers me on many levels. But I think I understand this concern. I'm not so concerned in Vermont. I've been involved in elections on the local level for a long time. I don't see those threats as being meaningful in Vermont. Nothing that a misdemeanor couldn't handle. Secondly, what about a potential 2-year misdemeanor is insufficient to address the conduct that we're talking about here? Is 2 years more or less meaningful than 5 years? If somebody were to actually be sentenced to prison for this activity, which I think is highly unlikely for the most part, I don't think there's anything about 1 year or 2 years or 5 years that is going to make any difference at all to the individual who is committing the activity. And finally, the issue of, I understand the issue with Kaya Morris, and probably more than people realize. Nevertheless, I mean, there were, as you know, there were law enforcement issues in Bennington County as well that regarding that investigation, and all I'm talking about again is proportionality. Does it, when we're writing a statute, does it need to be a 5-year felony? Is that going to make any difference to the people who get caught up in this, or the people who are perpetrators, intentional perpetrators of this? I don't support a felony. However, if you do a felony, make it look like other felonies. Make it an intentional act. Get rid of the affirmative defense and go from there. But does it, what about 5 years is magic as opposed to 3 years, which is also a felony? And if it's 3 years, what's the difference between that and a misdemeanor? Do people need a felony? Is that going to deter anything? I doubt it. I think it's a matter of, getting that person under either some supervision from the Department of Corrections and allowing them to get some, I don't know if it's treatment, but some sort of counseling to try to get their head straight on the way they're thinking. I don't know that a felony is the way to go about it.
I asked about the corrections too, and how we can make clear that if we exempt corrections.
Yeah, I mean, within when they talk about public accommodations, you're talking about a correctional center.
Okay.
I don't think that it's. I think it's clear that if you exempt that, that's different than somebody who makes threats outside of a center that would already be covered by this by the law.
Okay. Senator White has a comment or question.
I just am wondering about the definition of public accommodations, if in general that's too broad.
Unless you want to make a list of the various places where you don't want the threats to be made, the drafters of the bill obviously had that in mind. So I wouldn't have even thought to do that. I mean, why would it be why would it be, why would that even be it? I would, from my perspective, why would it be in there at all?
Yeah, because it clearly says that the way I read this, and I might not read it wrong, but it does clearly say that it is only this felony of 5 years with $5,000 if it will occur at a place of public accommodation. It does not, if you threaten me at my home, this isn't covered. This is just, so I don't quite understand why we would, if we're going to do something, why we would limit it to just something that's happening at a place of public accommodation. But that's just a question that I have.
Senator Baruth.
Yeah, I just wanted to echo that. This has been a piece that has confused me a little bit since I read the draft, which is, if I'm understanding it right, somebody issues a threat where they say, "I'm going to kill you," would be one thing. But if they say, I'm gonna come down to where you work and kill you, then it's 5 times the penalty. And that just seems very odd to me. It's not even like an aggravated scenario where we add a penalty or a hate crime. It's just that they added a location to the threat. And since I think a lot of these threats are issued in the heat of the moment, and that speaks to Matt's comments about intentionality, I could see somebody just throwing on, you better watch when you're walking into the grocery store because I'm going to be there for you. And would they ever have any way of knowing that that's 5 times the penalty for adding that to their threat? So I have to say that's the piece of the bill that I find most perplexing.
Well, I can try to explain it as one of the sponsors of the bill.
Yep.
What we're attempting to get at, without naming just election workers, that's, the request came from condos, Rory Thibault, drafted based upon the federal. But we were also looking, what about the store owner who's threatened over a mask mandate, and his or her employees are threatened because they're enforcing a mask mandate? What about people that are, a school board that's threatened, for example? So I didn't really want to go to just government employees, which is McCormick's bill. I just thought that, we should be concerned about anybody who's threatened, whether it be a government employee or any other person. So that's the reason for the, as far as I'm concerned, that was the reason for putting in the felony in the group of persons or individuals. We can certainly debate that when we get to markup. Senator White.
So I'm going to ask Matt if you can. It always makes me nervous when we create a new law and a new crime when there are, as you said, there are already statutes that take care of this. Would you send us what those statutes are so that I can see them?
Sure.
Thank you.
Yeah. You want are the sites alone okay? Or do you want the actual paper? Or what do you want?
No. You can send me just the sites and I'll look it up on the.
Okay.
Yeah.
I will do that.
Thank you.
Okay. Any other questions or comments from Matt? Matt, thank you very much for joining us.
Okay. Thank you.
Our next witness, is Harrison Stark, a new attorney with the ACLU, and welcome to Senate Judiciary, Harrison.
Thank you so much, Senator Sears. Good morning to all of you. I believe my camera is blocked.
Yeah, we can see you, but we can see a picture of you, but we can't see you live. I don't know
Can't even
why.
see a picture.
I appreciate that. Peggy, is it possible to unlock my camera?
Yeah, let me see. Hold on.
Wonderful. Thank you so much.
Hi. Yes, there you go. That should work.
Wonderful. There we go. Thanks so much, Peggy. And thank you very much, Senator Sears, and good morning to all of you. It's wonderful to see you. My name is Harrison Stark. I'm a staff attorney with the ACLU of Vermont. As Senator Sears mentioned, relatively recent addition to the staff. I started in November, so unfortunately haven't gotten the chance to meet you all in person, but hope to do so soon. This is actually my first time testifying before the committee, and so I'm particularly grateful for the opportunity to appear today. But I know I speak for the entire organization when I say how much we appreciate the opportunity to appear and weigh in on this important piece of legislation. I want to start today by acknowledging the truly extraordinary work that Vermont's election workers and public servants have accomplished over the recent past, and by talking about the profoundly disturbing democratic climate we currently find ourselves in. I mean, to be blunt, the ACLU is extremely concerned about the current state of our democracy and the toxicity that surrounds the ability of public servants to serve the people of Vermont and to do their job. I mean, this committee has heard from a number of individuals about the severe personal toll some of these threats can take on workers, but I think that these threats are partially just so disturbing because they strike at something deeper. As you've heard from Jim Kondos and some others, public servants and election workers are really the backbone of local self-government. As Chris Winters put it, they're really the cornerstone in many ways of our democracy. And so these threats are more than just attempts to threaten or intimidate particular individuals. I mean, I think they really are attempts to undermine our democracy, to erode the machinery of self-government, and to force particular people essentially out of public life in Vermont. And so this is something that goes to the heart of the ACLU's mission. And I want to be clear that as an organization deeply committed to protecting the voting process, we are equally committed to making sure that law enforcement and the state has the tools it needs to make sure that public servants from all walks of life in Vermont have the ability to do their jobs free of harassment, free of threats, and free of the fear of harm. The reason I'm here today is because we don't see S-265 as being necessary in order to accomplish that worthy goal. That's because in our view, the existing prohibitions in the bill are sufficient to protect workers from bona fide threats consistent with the First Amendment. As you all know, the current statute, as enacted, makes it a crime to knowingly, quote, threaten another person and to, quote, place the other person in reasonable apprehension of death or serious bodily injury. That prohibition, by its clear terms, already gives law enforcement the ability to prosecute individuals who make bona fide threats to election workers and other public servants. And we think that conduct prohibits some of the threats that we've heard about, both in testimony here and through public reporting in Reuters. Turning to what S-265 proposes, it proposes adding language essentially confirming that it's illegal to level a true threat against a group of persons or a person in a group of persons. And in our view, that language is both superfluous, it's unnecessary, and it also risks potentially chilling protected expression and certain forms of political hyperbole. First, as to whether that language is essentially fully needed to protect groups of Vermont's workers. We think the answer to that is no. There's been some discussion about whether the existing statute already prohibits threats against groups. We understand the statute to already prohibit bona fide threats directed at either singular individuals or groups of individuals. Any true threat that would be a valid process, that would be able to be prosecuted to the full extent of the First Amendment, we think would necessarily entail a threat at least against another person, which is what the statute currently prohibits. There's also been some suggestion that these additions are maybe necessary to bring Vermont's law into conformity with the federal standard. As you heard from Julio Thompson earlier today, that there are some ways that the federal statute and Vermont statute differ, but this is not one of them. The federal statute merely prohibits any threat to injure the person of another. It doesn't include this group of persons or persons in a group of persons language. What one response to all this is, that's all well and good, but sort of what's the harm in making sure that this is extra clear and including the sort of group language? We're concerned that including the language as currently drafted risks accidentally chilling certain forms of political hyperbole. Specifically, we're concerned that those who are charged with enforcing S-265 on the ground will look to the reference to a group of persons and potentially apply the statute over broadly, going after speech that's merely critical of certain groups without crossing the line into the specificity that's needed to be a true threat that's consistent with the First Amendment. Senator White, I think your exchange with Julio earlier, really captured this nicely. With your firefighter example, I think an example, if someone graffitis, kill all firefighters or kill all lawyers, that vague statement isn't the type of true threat that's specifically directed at another person or a group of individuals necessary for the First Amendment. But looking just at the plain language of the statute, we're concerned that somebody could reasonably say, well, firefighters or lawyers, that's a group of persons. So maybe that is actually prohibited. But that's clearly protected speech. Because we think that this group of persons language is both unnecessary and risks potentially having this chilling effect, we'd encourage the committee to leave it out, or at the very least to modify it with the particular modifier that we referred to in our written testimony. S-265 also proposes.
Could I
oh,
just?
Please, absolutely, Senator Booth.
So I understand your point. Kill all firefighters is a general threat, but we are living in a I don't want to say unprecedented time because our country has had civil war in the past. But over the last year, there have been threats coming from people who talk about the Second Amendment, talk about shooting Democrats, issue threats to arm up, lock and load against Democrats. And I'm wondering, is that really protected speech to the point where somebody might simply spray a room of Democrats with bullets? At what point would a prosecutor actually say, okay, this person is threatening a group, but they are credibly threatening that group?
Certainly.
You see my question?
Yeah, absolutely. And I think that this touches on some of the difficulties of legislating this area. I mean, the Supreme Court has defined a true threat. The line that the Supreme Court has drawn in terms of differentiating a true threat from just hyperbolic speech is really the intent to place somebody in fear of bodily harm. And so in order to be a constitutional prosecution of a true threat, and this is a standard that the Supreme Court has set, it's not set by this legislature or Congress or anything else, is that the speaker has to actually intend in some way for the listener to hear the threat and to place the listener in real, fairly imminent fear that they will be injured or harmed in some way. And so there may be instances in which a speaker to a crowd really does intend a true threat in that way, and that could be able to be prosecuted. I think, unfortunately, in most circumstances, that type of statement that you described probably can't be charged under the First Amendment. But unfortunately, that there's nothing that either this bill or any other bill can do to address that problem unless the Supreme Court changes its standard.
Is that part of what you're calling political hyperbole?
I think that would, yes, the Supreme Court has talked about true threats or this sort of inexact political hyperbole. And if it's not a true threat, it would be a political hyperbole, as you just described.
Okay, I thank you for that. I guess I'm just registering a caution to what I hear you saying, which is that we want to avoid chilling political hyperbole, if that form of, to me, that smacks of inciting a criminal act. And if that's what we're laboring to protect in a version of this bill, then I think we're working at cross purposes with ourselves in terms of keeping public order. So I just note that, and I thank you for your answer.
Yeah, absolutely, Senator. And I think it's a great question. And I want to be clear that we heard a little bit about Brandenburg v. Ohio earlier today, and there are some subtle differences between incitement to violence and true threats. And we understand this bill to be directed, and the current criminal threatening statute to be directed purely at true threats, as the Supreme Court has laid out in cases like Black v. Virginia. And so, if this committee returns to the issue of incitement to violence, we want to have a further conversation, and I'd be further prepared to testify on that. But for the true threat purposes, this distinction that we're talking about, I think is the key one. I just want to be clear that it's really this group of persons language that we're concerned about. I mean, there's a couple of other additions to S265 that have been discussed today, including adding a language prohibiting threats to harm third parties, like the family members of public servants, or to remove the affirmative defense. Again, we don't see those existing parts of the statute as barriers to prosecuting some of the threats that we've read about and heard about. But if the committee wants to amend those provisions, we don't have any constitutional objection to it. It's really this group of persons language that concerns us. I'll just close by reiterating how grateful we are to the committee for taking the time to strike the appropriate balance here. I think we heard earlier a reference to the ACLU's testimony as being aimed at protecting the sanctity of the First Amendment. I'm not sure quite what that was a reference to. We don't use that phrase in our testimony. And as I mentioned earlier, this is an issue that really strikes a balancing, incredibly important values that we don't see as being in necessarily fundamental tension with one another. When it comes to crafting criminal statutes that are affecting speech, as this committee knows, the specific wording that the legislature uses is tremendously important. And so we just really appreciate the committee's attention to really getting this right and making sure that prosecutors have the tools that they need to go after true threats that are really directed at public servants, and to protecting the bounds of the Constitution. With that, I'm happy to answer any additional questions.
Are there any further questions? Oops, somehow I undid myself. Are there any further questions for Mr. Stark? Thank you. It was very clear and good testimony. I appreciate it. I'm always, it's interesting. We have these conversations about bills, and there's always several sides to the issue, not just one in opposition, one in support. I think your suggestion of particular group is a good one. I'm not sure I would want to strike all of the group, but my understanding was when we drafted this bill, it was to get us closer to federal law. And you cited Virginia versus Black. So your argument is that it's already there, that the law already allows that. Is that correct?
So for Virginia v. Black, Senator, yes, that is the clearest articulation that the Supreme Court has given of what constitutes a true threat. And the definition that they gave there was that a true threat is a serious expression of an intent to commit an act of unlawful violence to a particular individual or a group of individuals. And that's made with the intent of placing the victim in fear of bodily harm or death. and as you heard from earlier today, there are a couple subtle differences between Vermont's current statute and the federal statute. For example, whether it's serious bodily injury or death, as opposed to just injury or death. Again, we don't see that difference as being a barrier to prosecution for some of the threats you've heard. I mean, some of the threats that have been recounted to this committee are incredibly harrowing and absolutely go towards the serious bodily injury standard that exists in current law. But
What about
please.
Well, I'm looking at this and I'm thinking of a particular case where the Agency of Natural Resources didn't go to a place because their investigators were in fear of what might happen if they investigated this particular place. And there was confusion, at least, that the state police wouldn't provide security for those investigators. And then we have the case where employees of the Secretary of State are threatened, and the state's attorney in Washington County determines that the threats are not chargeable under Vermont law, and suggests that the federal law could be applied. You know, if the federal law were enacted in Vermont. So that's, I guess, I'm questioning if you're familiar with that, those two circumstances. Both are, we don't know if anybody actually threatened the investigators with the Agency of Natural Resources, but they were certainly fearful of doing their jobs.
Certainly. So I think if the individual made those statements with the intent to put those investigators in fear, that would absolutely be a true threat that could be chargeable under the First Amendment and under the statute as currently drafted. As to whether differences between Vermont's current statute and the federal statute are barriers to prosecuting some of the threats we've heard about, we don't see any material differences that would prevent bona fide true threats that would be chargeable under the First Amendment, we think would be chargeable under the current statute. I mean, of course, if something is constitutionally protected, you'd be unable to prosecute it under Vermont law, under federal law, and under sort of any statute, regardless of how it was drafted. But to the extent that any of these threats fall within that window of chargeable true threats, we don't see any material differences between the statute as currently drafted and federal law that would allow for prosecution or otherwise.
That's helpful.
And Senator, I just want to return very quickly to Virginia v. Black. And you mentioned that you were interested in potentially amending the group of persons language. And I just want to say in our written testimony, we suggested potentially saying a particular group of persons. I think maybe an even better formulation of that's closer to what the Supreme Court has said, would be a group of particular persons.
Okay. Thank you. I think Senator White has a question or comment.
Well, I don't know if this is a question for Mr. Stark or who it's a question for, but I'm just thinking about the horrific time that Mr. Lawton and Kaya went through, and was it because our statutes were too weak, or did part of it just revolve around the way it was investigated and the timing and stuff? I don't know, but there certainly was there were some issues around the way it was investigated and the timing on it and stuff. So I'm trying to sort that out in my mind about how much was due to the weakness of our statutes and how much was something else. I guess that isn't really a question necessarily, it's just a pondering, unless somebody has an answer.
Yeah, that's really accurate. I think we're all wondering, when the state's attorney in Washington County says we can't prosecute but could under federal law. Makes you, that's really the genesis of the bill. Other questions, comments? Why don't we spend a couple of minutes with Ben, and then we're going to switch to S30.
Thank you very much for your questions. And
Thank you.
thank you to this
Appreciate
committee.
it.
And also thank you again to Jim Condos and his staff for their tireless dedication to Vermont's democracy in some truly grueling conditions. Thanks very much.
Thank you. Good morning, Ben. Thank you.
Morning.
So we've had a number of suggestions for changes. I think one that might be helpful would be to some carve out for people living in correctional facilities.
Can I ask Ben a question?
Yeah.
Ben, I sent you a note asking you about, and I'm embarrassed to say I don't remember if it was this bill or something else, but I thought in this bill it said, depending on where the communication comes from. And you sent me back an answer, but that isn't in this bill. Am I right? It's someplace else?
Well, as far as this bill, I mean, there is a location element, and Senator DeRuth had talked about it before, is that where the threat is threatened to be carried out.
Right.
That has to do with the enhanced penalty and public accommodation considerations as well. Is that what you're referring to?
No, it might have been another bill, because the way it read was that depending on where the threat comes from, by phone or by email, so I guess it's in a different bill, so I'll just forget about that for now. I just couldn't remember and I couldn't find it in here.
Okay. I can
Thanks.
search
Sorry.
through my emails as well, and just, we can communicate separately as
Okay.
well.
So would everybody be interested in an amendment that would further clarify, or do you want to get rid of groups of persons? Senator Bruce.
I like the suggestion from Harrison Stark about a group of particular persons. I think that's an important part of the bill. It makes sense to me, but that language sounds better than the bill currently just reuses person over and over. And I think it gets a little mushy, and that group of particular persons, especially if it's drawn from Supreme Court precedent, seems like a good addition.
Mm-hmm.
And Chairs, here's if I may, I've been the wheels have been going in my mind about different alternatives as well. And I think the suggestion of group of particular persons could work. I think we could get even more specific if we wanted about, which types of people. But I know that there was hesitation about going too far in comparison to the other bill that might be taken up later. But I just wanted to put it out there that there are various approaches that we could take depending on really what the policy is to be.
Yeah, I'm it may be just me, and we will talk about it when we get to the real markup, but I find it problematic just to use the term government employees or whatever the McCormick bill does. And I know Senator McCormick is really firm that he believes in that, but I just singling out government employees is the only ones that can be harmed by threats and of violence, etc. It's just I don't want to. I find that something I don't really want to do, but there may be other members of the committee who think that that's a good idea.
Dick, can I
yeah.
chip in? The more you have, let me rephrase that. When I see the term group of persons, to me, it increases the likelihood that someone is speaking in hyperbole. I was listening to Philip a while ago talking about the current nature of things. And if somebody has been demonstrated to, I'll call it the Republican right wing, arguing that some particular group of people ought to be exterminated or whatever the case may be, I flipped that around in my head and I asked the question, what would happen if somebody, for instance, in the Black Lives Matter movement was saying the same thing about right-wing Republicans?
They would
To me, that's somebody speaking in hyperbole. In the political comments of our current situation, in the midst of what we're currently facing, a prosecutor who is oriented towards one side of the political equation might see it as hyperbole, and a prosecutor on the other side of the political persuasion might see it as, no, that's definitely a threat. And I find it really problematic if you're not specifically targeting one individual, you're just increasing the likelihood that a person is exasperated and speaking in hyperbole. I presently represent a person who was in the midst of having their child removed by DCF and made a direct comment to the individual in DCF. I can understand why that's a threat. But in the moment of that heat of passion moment, was it frustration? If they had said you and everybody else in DCF, I'm increasing that hyperbole suggestion. I'm not sure I'm articulating this properly, but I just don't like that phrase at all. And it causes us to walk into a minefield trying to figure out whether or not this was serious or hyperbole. Okay, I'll leave it at that.
I'm reading this different than you are. I'm reading it that threaten another person, a group of persons. So if I threaten one member of the Judiciary Committee, it's the individual member. If I threaten the whole Judiciary Committee, then it's a group of Judiciary Committee members or all committee members. That's how I'm reading it. The threat is not by a group, it's by an individual towards either another individual or a group of persons.
And if I might, Mr. Chair?
Yeah.
I agree. And that's why I was suggesting groups of particular persons. So
Yeah.
you're in some part of your speech, you're particularizing the threat and you're increasing the sense of those people that there's an actual threat to their person because they are part of that more narrowly defined group. So to go back to Joe's point, your original point, I don't disagree with. I think somebody could issue a vague threat to all Democrats or all Republicans. In my example, I was trying to indicate that, and you used the phrase Republican right wing, I'll use it too. There has been a tendency on some people's part in that group to issue threats that they then connect to their own weapons, other people's weapons, so connecting the vague threat to actual weapons and, sometimes even a place. Like there was a Republican candidate who a day or two ago suggested that people come to the polls armed and respond to things that they didn't like. So I don't think in this bill we need to get that broad-based in what we're responding to, but I do think that the attempt to try to capture a specific group of people like the Judiciary Committee, like DCF workers, et cetera, is a useful part of this bill. I suggested group of particular persons as a way to do that, but it may be that there are better ways, but I think that that's something we should be trying to get at.
I'm going to stop here because
Okay.
we need to do the walkthrough of S30 and pick
Okay.
up with this bill at a later time. Thank you, Ben, and thank you all to Harrison and the other witnesses, as well as Matt Valerio and others on S30. And we'll move on to Mr. Eric Fitzpatrick, whom we haven't seen in days.
Yes. Good morning, everybody. Nice to see you.
Nice to see you. Well, we passed a simple little bill that had a study and a ban on hospitals, possession of firearms in hospital buildings. And it's expanded. So I was hoping we could go through the expansion and then hold a hearing tomorrow at, Peggy, if you could cancel S179 for tomorrow.
Mhm.
And we'll start at 10. We'll take our break at 10:15, and from 10:30 to noon. Witnesses who would like to speak on S30 would be invited to join us.
Who should I invite?
Well, I'm sure they'll invite themselves, but if you could check with Adam Necrossan on people who may support you. Also want to get somebody from the domestic violence, Jessica Barquist, and I'm sure that Chris Bradley would like to speak on it, and that perhaps somebody else. So, I mean, it's not going to be a long one, but I don't want to have this thing hanging around for months while we take it up.
How about Bill Moore? Should I invite him or?
No, I'm going to leave it up to Chris Bradley.
Okay.
If he's got one or two more that he'd like to bring, that's fine.
And then ask Adam.
Adam on the other side, and Jessica Barquist represents the network against domestic violence and sexual assault. So Eric, could you walk us through the version?
Yeah, I'd be happy to. Should I share my screen, Senator Sears? Would that be helpful?
Yeah, and one thing I'd be particularly interested in is any place where they made changes to either their own bill, which I think was H133 on the domestic violence,
Correct.
and changes to our bill, which was S30 with the hospitals and the study, and any changes to S5 that was introduced regarding extreme risk protection orders and an exemption from HIPAA.
Yep. Yeah, I can absolutely note those things as I do the walkthrough. That makes good sense. So I'll pull up the screen. Actually, first, just for the record, Eric Fitzpatrick with the Office of Legislative Counsel to walk the committee through the House passed proposal of amendment to S30. And I'm going to pull that language up now. As Senator Sears mentioned, as it passed the Senate, it was entitled an act, and still is entitled, an act relating to prohibiting possession of firearms within hospital buildings. And the House proposal has several additional pieces, which I will go through as I do the walkthrough. And here we have the House proposal of amendment. Does everyone see the screen okay?
Yep.
Okay, good, thank you. And since I can't see you when I do the walkthrough, please feel free to interrupt me or stop me as I'm going along if you have questions or comments or want me to slow down or anything like that. So the section 1 is S30 with one change, which I'll point out in a second, but this was in S30 as it passed the Senate, and this was the prohibition on knowing possession of firearms within a hospital building. So I'm sure everyone remembers that. That language that basically prohibited a person from knowingly possessing a firearm while within a hospital building It's a location restriction similar to the ones that Vermont has for courthouses and school buildings. The one change that was made is in the penalty, and that's in subsection B. You'll see right there that in the House proposal of amendment, it is a fine of $250. When it passed the Senate, it was a 1-year misdemeanor. And I believe that the fine was at one maximum of $1,000. So it was a 1-year misdemeanor, $1,000 fine. The House reduced the penalty to a $250 fine, maximum, I should say.
And that's
Other than
it.
that,
There's
that's it.
no-
That's the only change. Correct.
So there's
Well-
no jail time. It's just a $250 fine.
Exactly.
The only thing I would point out is that they did get rid of the study. That's another change to S30.
Yes, that's right. The study by the Capitol Complex Security Commission on the possession, on whether firearms should be, how they should be regulated in the Capitol complex. Remember, that was also a piece of S30. So, and that was removed by in the House proposal of amendment.
So they took out I just want to make sure. It was a year in our bill, and they reduced it to a $250 fine, which okay. Thank you.
That's it, exactly. So that is section 1. Section 2 deals with the federal, sorry, actually the general background check provision that is both in federal and state law now. You remember several years back in 2018, this section of Vermont law was passed, 13 VSA 4019, requiring background checks between many firearms transactions between private persons.
Yep.
Sorry, was someone saying something?
No, I said yes.
Oh, okay, sorry. Thanks. Sorry about that. So yeah, under federal law, the background check requirement applied when a firearm was transferred by a federally licensed firearms dealer known as an FFL. When you guys passed the law in 2018, it was expanded to some private transactions. And so this applies either way, whether it's through a dealer or through a private person. Remember, the process of it was that it's the dealer who has to facilitate the check. So in other words, even if the transaction is between two private persons, they go into the dealer calls the National Instant Criminal Background Check System, known as NICS. And the NICS system looks into whether the person is prohibited or not, to look into categories that this committee has talked about quite a lot over the years, whether the person is convicted of a certain crime or whether they're subject to a restraining order. Maybe they have a misdemeanor domestic violence conviction, or they've been involuntarily committed for mental health treatment. There's a long list of categories, but that's what the NICS check is trying to find out. Does the person fit into one of those categories so that they would be prohibited from possessing a firearm, in which case they would not be able to make the purchase. So that's the general setup for how NICS works. But this addresses what in sort of popular terminology, in legal terminology, it's called a default proceed process. There's some popular terminology that refers to it as the Charleston loophole. From a legal perspective, it's the default proceed, and that's the term that I use. And just to sort of explain to you how that works, I'm going to take a quick look at a piece of the background check provision in federal law. So as we said, the NICS check is done when the dealer contacts them and says, this person is proposing to buy a firearm. The NICS system looks into the person's records that they have in their database to see if they're going to be prohibited for one of the reasons. There is what's known as a default proceed, and that's what this section of the bill addresses, the default proceed. And how that works, we're just going to take a quick look at the language right here so that you can see it. Here it is the way this process works is that, as I mentioned, the dealer contacts NICS, and then one or two things needs to happen before the firearm can be transferred. And this is in B, Roman numeral 1 and Roman numeral 2. So, well, you can start with A, I guess. Before the completion of the transfer, the licensee, that's the dealer, contacts the National Instant Criminal Background Check System. And then one of these two things have to happen. Either one, the system provides the licensee with a unique identification number. And that happens. The unique identification number really means that the person is okay, that they've passed, they have it, their name has not come up in any one of these databases. So when NICS determines that, oh, this person isn't prohibited for, any one of these reasons under state or federal law that they would be prohibited, then they give the transaction a unique identification number. They pass that along to the dealer and the transaction can proceed. So that means that the background check hasn't turned up anything and the transaction can go ahead. Or another thing could happen, and this is the default proceed, Roman numeral 2 there. 3 business days have elapsed since the licensee contacted the system, and the system has not notified that the licensee that received a firearm by the person would violate GRN, that means state or federal law. So in other words, if the background check within 3 business days isn't finished and hasn't come up with an answer for the dealer to say, hey, this person is prohibited for a reason A, B, or C, whatever it might be, then the transfer can still proceed. So that's why it's called a default proceed, because an answer hasn't been provided yet, but it can still go ahead. And yet, you see, remember, an important term is may. In other words, it's not a requirement that the firearm be transferred after 3 business days have elapsed, but it can be done. And so if we take a quick look back at the language in H30, you'll see it addresses that situation, that default proceed. Here's language added to the background check section. It says, I'm in subsection D, the underlying language, provides that the person can't transfer a firearm to another person if, and 2 things have to happen. 1, transfer requires a background check under this section or under federal law. Because remember, some transfers don't require the background check. There's immediate family and their law enforcement. Some other exceptions don't require one at all. But assuming it does, if the background check is required, then the transfer can happen until subdivision 2. The licensed dealer, that's right. The firearm can't be transferred if the licensed dealer has not been provided with this unique identification number by the NICS system. And that's, as we say, that's the number that shows that the person is not prohibited. Now, the last clause is important. Provided that if the identification number has not been provided within 30 days, then the transfer may proceed. And essentially, you see, it's similar to the default proceed that you just looked at in the federal law, except that the federal law default proceed was 3 days, and this is extending that to 30 days. So in other words, if the background check begins, 3 days passes, there hasn't been an identification number provided to the dealer by NICS yet. In other words, they have it for whatever reason, and there's all kinds of reasons that, maybe there's criminal records aren't totally clear and they have to do some further investigation. There's many reasons why they might not have an answer within that 3-day period. If they haven't, then the transaction cannot proceed until further amount of time has gone by. And you'll see, for example, on day 5, if they have not provided an answer yet, transfer could not proceed because you have not reached that 30-day maximum yet. So it extends that 30-day period. Now, as a practical matter, this actually closes the default proceed fully, because if we look at another federal regulation that's very important here, and this is from the federal regulations, this is also federal laws, the regulations of the Bureau of Alcohol, Tobacco, Firearms, and Explosives. And in their regs, you can see subdivision, this is just sort of subdivision 2 there repeats what we were just talking about, that, that in order for the transaction to proceed, NICS has to inform the licensee, that's the dealer, that there's no information that the transferee would be in violation of federal or state law, and they have to get this unique identification number. Or the 3 business days have passed the default proceed. That's just what we talked about just now. But there's an additional provision, and that's subsection C here, and that's a time limitation on NICS checks. So what this provides is that a NICS background check is only good for 30 calendar days from the date that the NICS was initially contacted. If the transaction, I'm looking now, that's the last sentence in subsection C I'm moving on to. If the transaction is not completed within the 30-day period, the licensee, that's the dealer, shall initiate a new NICS check prior to completion of the transfer. So the background check is only good for a 30-day period. Now, remember, if you look at the language proposed in S30, this provides that the transaction can't proceed unless they get a positive answer from NICS within 30 days. So the practical result of that is that this default proceed process is fully closed, in the sense that, if there's not an answer provided within that 30-day period, then the clock restarts and the background check has to be resubmitted. Now, there is an appeals process through which a person can voluntarily submit information about themselves, background information, so that for future background checks, or even within the same one, they can move it along, they can expedite it, so that the investigation.
Eric?
Yeah, please.
Am I right that when we passed the waiting period legislation that made its way to the governor's desk, didn't that also completely close the loophole, because we said that you couldn't transfer the firearm until the background check was completed?
Yes, that's correct. Now, the language was different, but yes, the practical effect of that was the same. So that the default proceed process was fully closed under, I think it was
Yeah.
or maybe just 169, right?
Yeah, S169. So in other words, this is consistent with what we've already passed out of the Senate in S169.
Yes, I would say that's fair. Yep, that's an accurate sort
Hey,
of
I'm
comparison. of
looking
the
at
two.
the clock, Eric, and I'm saying we're not going to finish this today, which means that I'm getting pressure from various quarters to get this out of here tomorrow.
Mm.
And we put aside everything else to do that. So, are you available tomorrow, Eric?
I think so. Let me just double check my morning calendar here.
You were here for 179 and I just changed the title.
Okay.
We already
Oh.
had him. We already have him from now 10:30 to 12.
Well, that works great. I love it when that happens.
Me too.
All right. All right. Well, if you can keep going, Eric, but we're not going to get through all this walkthrough. And I'm under pressure here from the Pro Tem's office and others to move this out of here as quickly as possible and put everything else aside.
Sure. Well, I'll try and pick it up a little bit. And I think this was one of the more complex sections. So I think that some of the other ones might go a bit quicker.
Okay.
Can I ask a question about this, or should I wait?
No, go ahead.
I'm confused here, because what we passed said that until the background check was complete, there couldn't be the transfer. And what the federal law says is that if it isn't complete within 3 days, then the transfer can happen. And what this said, but it also says that if it isn't completed within 30 days, they have to start over. But this says if it isn't completed within 30 days, then the transfer can happen, not that it starts over. So this is, as I may be wrong here, but this seems to be in conflict with the federal law that says if it isn't completed after 30 days, it has to start over. And this says if it isn't completed within 30 days, the transfer proceeds.
Well, I think that it's a good point, Senator White, that that you have to look at the interplay between the two of them, and that the federal law is going to apply. In other words, we can't legislate our way out of the federal law. So that 30-day maximum after which the background check has to be resubmitted, has to be restarted, right, that's going to apply. So then
this is irrelevant.
Well, no, because I think under the federal law, let's say this statute didn't exist, then let's say at day 5 or day 10 or one of those other days, then the transaction could proceed
Right,
because of the default proceed. So if you have this in place, then the transaction can't proceed during that 30 days because you also have this Vermont law applying. It says, hey, if they haven't got a number back within 30 days, the transfer can't happen. It just
Right.
so happens that because of its interplay with federal law, that means that each 30-day period is going to have to start again. So that,
Right.
you have to get a positive result from NICS at some point in time before the transaction can go forward.
no, but if this says that if on day 31, there hasn't been a deposit or the unique identification number given, then the
Right.
transaction proceeds. But the federal law says that on day 31, if there hasn't been, the whole thing has to start over. So I don't understand.
Well,
This seems to be in conflict with the federal law.
Well, it is different, but the federal law controls by virtue of the supremacy clause in the Constitution.
Right, so then
So-
why would we have this here? Because it is in conflict with the federal law. I don't get that.
I don't think it's in
Anyway.
conflict. I think it just, by putting it at 30 days, it means that you start over again. And they would have been better off to say, to do what we did in the other bill that Senator Bruce.
But
Or-
that isn't what this says. This says then the transfer may proceed.
But it can't.
Well, that's what it says.
I understand that, but it can't. As under the federal law, am I
Right.
correct, Derek?
Yes, that's right.
So, if you
this
did
is wrong.
15, if you did 15 days, then it could, but with the 30 days, you can't.
Right.
So anyway.
Yeah,
Good
I think that's
pickups.
right. With a shorter period, it would work that way.
Yeah.
All right. Section 3 does something.
Yes, absolutely. Section 3. This is the piece that you mentioned, Senator Sears. You may recognize this. This is in S5, and it was also in S169. That was also passed by the legislature, and that was the one that was vetoed by the governor because of the waiting period. But this section was
Right.
in that same bill, and this hasn't been changed at all from S5 or from S169. It's identical. And this basically just trues up the ERPO law, the Extreme Risk Protection Order law, with the federal HIPAA standard. And you may recall that if you look at subsection D1 there, the first 4 lines of this page, basically from about the end of the second line on, the provider believes in good faith. That language is verbatim. That's just cut and pasted from HIPAA. And I'm going to show you another thing real quick here in HIPAA and remember, HIPAA generally prevents the disclosure of health information by covered entities, generally speaking. But there is a list, of exemptions, of basically reasons for which, despite the general prohibition, the language may be disclosed, but for some reason that site is not coming up. So,
Well, I think we all recognize this as a piece we've already passed.
right.
And so I think you can go right ahead to the annual reporting section
That was
4.
that was in the same bill, actually. That's
Okay.
also
It's
hasn't
all
been changed.
F5 and
Yep.
S169.
Yep. And that's just we're asking the court and AHS to report on data on extreme risk protection orders, the number that are issued, what county, that kind of thing.
Yep.
Section 5 also was a version of it. The language is a little different. This was also in 169. This has to do, you see, with large capacity ammunition feeding devices. These are the high capacity magazines. Remember, they were prohibited also in legislation that you passed back in 2018, but also there were a number of exemptions. And one of the exemptions, you may recall, was for the use of these high capacity magazines for shooting competitions by out-of-state residents. Remember that one?
Is
Now-
this exactly the same as in 169?
It adds a little bit of language. It's the same, but it uses the word organized shooting competition. I think it was established in the prior version. And then it adds that little language on by an entity, so it has to be, this competition has to be sponsored by an entity registered with the Secretary of State. So that's added to sort of clarify, what sort of sponsorship is going on with the shooting competition. So as long as it's, and it basically just, the problem with that, not the problem, but the issue with the language that you had before was that it sunset. It had a sunset attached to it. So this
Right.
basically reenacts that language
Good.
with the additional piece that I just mentioned.
All right, Eric, we're 5 minutes at 12 and I want to make clear something. Tomorrow we'll try to hear from people. So Peggy, when you do the agenda, starting at 10:30, each try to hear from people between 10:30 and 11:30, and then give time for the committee from 11:30 to 12 to make a decision. And our decision, by the way, is not to pass a new version of this, but it's whether to concur with the House provisions of amendment, whether to concur with further proposal of amendment. For example, you could, if you didn't like the change they made to S30, the original S30 that we passed, you could put the misdemeanor back in and the fine raised up, for example. And that, or we would ask for a committee of conference. So that, just to making clear, the reminder of what our choices are. And I know I'm going to get heavily criticized for saying I'm going to try to do this tomorrow, but we've dealt with most of this bill except for section 6. And section 6 is it H133, Eric?
Yep, exactly.
And we did have hearings on that as well.
Yeah. And there is I'd like to hear from Judge Donay too on this tomorrow, if we could, on section 6, Peggy.
Yep.
I think the testimony was that it's something the judges can already do, but they want it in law, so it's consistent around the state. That's my understanding.
Yeah, I think that's
So-
right. So you'll see that the new language is in subdivision E there, section 6. It has to do with emergency relief from abuse orders. And it adds to the, you see A, B, C, and D are what things that can be in these emergency relief from abuse orders now. And it adds another piece to those things, which is that the order can include a piece that would require the defendant to immediately relinquish firearms for the time period that the order is in effect.
Am I correct that the basic concern of the various groups is that that there is no notice to the individual? Excuse me, my dog wants out. There is no notice to the person whose firearms are being taken.
Yes, this is one of those emergency orders that only lasts for 14 days. It's kind of like the ERPO emergency orders. There's no notice in the emergency one. The court has to have a hearing within 14 days, and they have to have notice for the final hearing, but not for this one. No.
Okay, I guess
So it can be ex parte, in other words.
Yeah. Okay. So that's even the person who owns the firearm may not know that they're required to relinquish their firearm.
Not until the order is served on them, right?
Right. And they have no recourse for 14 days.
Well, they could try and get the hearing sooner. They could certainly try that.
Okay. Well, I guess, it's noon time, so